I'm going to go ahead and call your case. This is McMaster versus DTE. This is a full grant. You each have 20 minutes. Ms. Patel, that means, as you know, you can try and reserve some of that for rebuttal, but we hope you'll take control of that yourself, and you may proceed if you're ready.
Okay. Good morning, Your Honors. May it please the court, Sima Patel on behalf of Plaintiff Appellant Dean McMaster. Your Honor, this court granted leave to appeal to address two questions. The first is whether MCL 480.11a, which adopted parts of the Federal Motor Carrier Safety Regulations, abrogated DTE's common law duty to act. The second question is whether DTE owed a duty anyway under the shipper's exception outlined under U.S. v. Savage. I'll address both in turn. Under the first question, I think under this court's precedent and looking at what the regulations set forth, it's pretty clear that the common law has not been abrogated in this case. Michigan law has adopted a comprehensive comparative fault statute. We recognize that more than two entities can have a duty of care to act at any given circumstances. This court's precedent in terms of abrogation of statute and also enshrined in our Michigan Constitution is that common law will not be easily or impliedly deemed to be abrogated. The legislature can abrogate common law by explicitly stating so in a statutory scheme, or the only time that it will be found to be impliedly abrogated is if the depth and breadth of the legislation is so comprehensive that it is impossible to read the legislation and the common law harmoniously in tandem. That's not the circumstances that we have in this case. When we look at the regulations at issue in 49 CFR 392.9, that section deals with obligations that apply to a driver of a commercial motor vehicle. It talks about what duties they have to inspect the cargo, to re-inspect the cargo, et cetera. It is silent as to what duties or obligations apply to a shipper. That's where the Michigan common law can come into place. Here, DTE, it is undisputed that DTE undertook to load the cargo container. They loaded the scrap container. We argue that DTE had a common law duty to use reasonable care in its undertaking. And it is completely possible to read DTE's common law duty of care to act in tandem with Mr. McMaster's duties. That is perfectly allowed under the comparative fault statutes, which recognize that more than one entity can have a duty of care to act and leaves it to a jury to apportion the fault and damages between the separate entities. Now, I think before I get into the shipper's exception, I want to talk about the U.S. v. Savage opinion itself and what I've termed as the Savage Doctrine. Now, U.S. v. Savage is a federal court case that applies federal common law from almost 70 years ago. Its analysis is based on a rubric of contributory negligence, and in that opinion, the court weighed the relative duties of the parties. It introduced concepts such as the last clear chance doctrine, an entity having a primary duty versus a secondary duty. All of these, which are concepts that our courts have shied away from, especially in light of our comprehensive comparative fault statutes. So under U.S. v. Savage, I think that the court should stay away from adopting any of that analysis at all. One point that is important about U.S. v. Savage as it applies to the abrogation argument is that even under U.S. v. Savage and all of the cases, Decker, et cetera, that have relied on U.S. v. Savage in interpreting these regulations, they recognize that there is an exception under which a shipper can be held liable, which is a de facto admission that the common law can be read in tandem with these regulations, that there is room for a shipper to be held liable in certain circumstances. Now, under Savage, that court held that the exception was narrow, and it's only when there's a latent defect and the shipper has affirmatively loaded the cargo. So if the first question is answered and said yes, that Michigan law is not abrogated and the Michigan statute does not abrogate Michigan common law, then the next question is, what law fills that void? Should this court be looking to U.S. v. Savage, which is a federal court case from under a contributory negligence framework, making federal common law, should that fill the void, or should the court instead look to Michigan common law to fill?
Ms. Patel, let me interrupt you and see what questions folks have, and then we can get back if we don't eat up all your time. Justice Viviana.
No questions at this time, thanks.
Justice Bernstein.
Hey, good morning. Just want to wish you a happy new year. Thank you for coming, but I don't have any questions for you now.
Good morning. Thank you. Happy New Year.
Justice Clement.
No questions right now. Thank you.
Justice Cavanagh.
I don't have any questions.
Justice Welch.
I have a quick question. Thank you, Ms. Patel. I'm wondering, with regard to Savage, I'm wondering, in your opinion, how does that differ from how Michigan has been applying the law in conflicts like this in the past?
So I think that the Michigan applies its statutes, and if there is a way to read the statute and the common law together, Michigan applies both. So with Savage, I think Savage is trying to carve out this narrow new common law with respect to the statute. It's saying that instead of saying that no duty applies, we're only going to have a duty apply if there is a latent defect in et cetera. But that's not what the Michigan common law says. The Michigan common law says that if you undertake to do something, you have a duty to use reasonable care in that undertaking. And I think that when defining what the DTE's duty should be in this case, it should be defined by Michigan common law and not necessarily common law from a federal jurisdiction that was enacted under a contributory negligence framework. Does that answer your question?
Yes, thank you.
Okay.
Justice Zahra.
No questions, thank you.
All right, Ms. Patel, you may continue and reserve when you are ready.
Okay, so then I think I've addressed the abrogation part pretty comprehensively. Then I move to the next part, which is the shipper's exception under U.S. v. Savage. Now, I don't think that this court should adopt U.S. v. Savage or its federal common law into Michigan law in any way, shape, or form. I don't think that the analysis and the rubric that it's based on is compatible with Michigan law because it's based on a contributory negligence framework, which we have walked away from. Now, I think defendants rely heavily on the fact that a lot of other cases have looked at or adopted U.S. v. Savage or Decker, which in turn relied on U.S. v. Savage. I think that it's important for the court to, instead of looking at the numbers of who has adopted what, to look at the underlying rationale of why. The vast majority of the cases that have been cited by defendant DTE don't address comparative negligence. They don't go into comparative negligence or how that plays into the U.S. v. Savage analysis. The few that have, I think I discussed in my reply brief, but the case that I would like to draw the court's attention to is the Spence case coming out of the Fourth Circuit. I find the Spence case very persuasive because in that case, the Fourth Circuit looked at Pennsylvania common law. It addressed a very similar question to the question the court is facing today. And in going through the analysis, it looked at Pennsylvania common law and filled Pennsylvania common law to establish what the shipper's duty in that circumstance would be. And I think that's a very persuasive analysis for the court to follow and is in keeping with Michigan precedent, Michigan common law, and giving full faith to both the Michigan statute and the Michigan common law. With that, I will reserve the rest of my time for rebuttal, unless anybody has any more questions right now.
I will see if anybody has any additional questions for Ms. Patel right now. Okay, you may reserve. Mr. Diemer.
Morning, Happy New Year. May it please the court. My name is Tim Diemer of Jacobs and Diemer. I'm here on behalf of the dependent appellee, DTE Electric Company. Let me start by addressing head-on plaintiff's proposed common law rule that would impose a duty of care on a shipper like DTE in these circumstances. I represent the appellee, so I'm playing defense here. And while I don't need to prove a negative it is telling that there is not a single case law authority from Michigan or elsewhere that has adopted the proposed common law rule that plaintiff is suggesting. Justice Welch noted that Michigan courts have already been applying the regulations and the Savage rule in Michigan for a number of years. We have the 3 unanimous judges in this case, 3 unanimous judges in Neal versus Steelmaster, an unpublished case that applied the regulations in Savage, citing the Decker decision. And we also have judges Avery Cohn, Judge Godola, and Judge Zatkoff applying Michigan law in federal district court opinions, applying Savage. And but this court has not weighed in on that decision just yet. The cases that plaintiff does rely on are, I don't agree with the description of them. For example, in Spence was a Third Circuit decision applying Pennsylvania law. In Spence, the court did adopt the Savage doctrine. It was adopted, but the plaintiff's claim was allowed to proceed because there was a question of fact on latency. And there was a question of fact on reliance. A number of courts around the country, when they address latency, it's not just was the hazard capable of being detected on reasonable inspection. That's not the only issue there. It's also reliance. In Spence, the shipper not only loaded the cargo into the container, but the shipper undertook the duty to also secure the cargo in the container. And when the plaintiff asked whether the load was safe to go, the shipper affirmatively represented, it's all set to go. You don't need to add any more bracing, any more securement. And the plaintiff drove off based on those affirmative representations and relied on those representations and was ultimately injured. The other case that plaintiff has cited is Smith. It's an intermediate appellate decision out of Iowa. It's unpublished and it's distinguishable in a very crucial respect. In Smith, the plaintiff was not injured as we have here after he arrived at his destination to drop off the cargo he was hauling. In Smith, the plaintiff was injured at the shipper's facility, on the shipper's premises, where the shipper had control, where the shipper was in the process of, in conjunction with the plaintiff, loading large fiberglass pipes onto the plaintiff's truck. During the process of the 2 parties both loading at the same time, the plaintiff was injured. Again, that occurred on the premises of the shipper, which is distinguishable and a very important factor, because one of the issues this court has traditionally looked to when deciding whether to impose a duty or not is control. Who has control here? Who's in a position to prevent harm? And again, in that case, the defendant was in the process of loading the pipes when the plaintiff was injured. The defendant was exercising control. What do we have in this case? The complete opposite. Mr. McMaster arrived at the DTE premises. The container was laying on the ground. He knew what to do. He didn't talk to anyone at DTE other than the security check-in when he arrived and when he left. He dropped off an empty container to be filled with scrap. He drove up to the full container of scrap. It was resting on the ground. Part of the loading process in this case was taking the full container from the ground and loading it up onto the back of his truck at a 45-degree angle. Mr. McMaster is the one exercising control. Let's just say hypothetically, in a different situation, a driver arrives at a construction site to pick up scrap material or something like that. And while the driver is there, the materials are actually being loaded in the container and the crane operator drops the pipe on the poor guy. Yeah, there would be liability there. The defendant is exercising control. Or let's just say Mr. McMaster, when he does his inspection of the container, climbs up the ladder and either DTE or a contractor had spilled some oil or something like that on the ladder, and he climbs up and slips and falls off of it. That's DTE's premises. That's under their control. That's not at all what happened here. DTE paid Ferris to remove these materials. It's garbage. It's refuse, essentially. And Mr. McMaster was the only one to exert control over this container, over the contents, from pickup, hauling to delivery. And the manner in which,
why don't I see what questions folks have, and then we can get back to you if we have lots of time. Justice Viviano.
No questions. Thank you.
Justice Bernstein.
No questions at this time. Thank you.
Justice Clement.
No questions.
Justice Cavanagh.
I just want to clarify. So if say we agree with you and we write an opinion that adopts the Savage rule, and explain how it can be consistent with our comparative fault system. What is I understand your argument to be that we can apply that there's no question of fact that under Savage there is no duty. Why, if we're adopting this, would we not officially in explaining how it works, or if we were to do that, why would we not remand that to the lower courts to then analyze it under what we are saying is the appropriate common law in Michigan?
It's a very good question, Justice Cavanagh. And Savage only can result in liability for the shipper if the shipper exclusively loads the cargo, and only if the cargo is loaded in a way that hides the defect from the plaintiff. The plaintiff is completely unaware. Now, this is also reflected in the regulations. The regulations themselves put the duty to inspect and secure on the plaintiff, but is relieved of that duty if the container is sealed or if there's no way for the driver to conduct the inspection. So I believe these go in tandem. But on your specific question of whether a remand is appropriate, the facts here are undisputed. They're undisputed that plaintiff was involved in the loading process when he, again, hooked his trailer up, his truck up to the container and loaded up at 45-degree angle up onto his truck. So he was involved in the loading of the container.
He wasn't involved in loading the scrap into the container, though, correct?
Correct.
And the placement of the pipe in relation to metal on metal, or how it was placed, or what's the best way to do that, right? It was loaded in such a way that the pipe was already there in whatever position it was going to be when he came there, right?
Correct. And my strategic mistake by leading with the weaker of the two arguments. The stronger of the two arguments is Mr. McMaster, and the trial judge noticed this, said he was the most honest opponent she had ever come across. He said in his deposition time and time again, when I climbed up the ladder and I looked inside the open air container, I saw the large bright blue pipe resting against the rear door. He said he knew it was there. He saw it before he left, before he loaded up onto his container, up onto the truck. When he got to the Ferris facility, he knew it was still there. Now, what plaintiff did not do that most drivers do, it's best practice, is most drivers will climb up the ladder again, or when it's being weighed at the Ferris facility, take another chance to look inside to see if the material had shifted. He was actually supposed to do that within 50 miles of his commute. He failed to do that. The regulations say every 50 miles, the driver must stop, inspect, and add securement devices if necessary, but he did not do that. He knew the pipe was there. He knew it was there at the DTE facility. He knew it was there when he got to the Ferris facility. He opened up, again, this is part of his training, was how to open the rear door of the container full of scrap metal when he got to the Ferris facility. And what Mr. McMaster was trained to do, and what he did do, is he cracked the door open just slightly to see if any loose materials had fallen out. Because everybody admitted when the container is loaded at a 45-degree angle, all the stuff, I'm not a scientist, but the gravity is going to force it all the way to the back, no matter how it's arranged originally by a shipper. So Mr. McMaster knew that pipe was there up against the rear door when he left, and he knew it was there when he arrived at Ferris, when he cracked the door. He knew it was there when he opened the door up all of the way. When nothing fell out, Mr. McMaster cracked the door, nothing fell out. He opened up all the way. He saw the pipe sitting right there, resting on loose material. So there is no question of fact of latency or whether it was a hidden defect. It's not a matter of he should have found it. He knew it was there. He saw it. It didn't concern him. And despite being trained and despite having common sense not to stand immediately behind an open door container, him and two employees of Ferris, it's a little unclear whether it was 5 minutes, 10 minutes, or 15 minutes, stood there cracking jokes with each other, waiting for somebody else to show up to tell them where to move this, where to dump this particular load, because they thought maybe it should go somewhere else. So there's no question of fact here on latency. There's no question of fact. And the Court of Appeals, I believe, got this. I know the Court of Appeals was reversed the first time they addressed this issue. Second time they addressed this issue, Court of Appeals got it exactly right. There was no latent defect here.
Thank you.
Justice Welch.
Yes, thank you. Counsel, I have a question. Ms. Patel brought up the point that most of the cases or most of the jurisdictions that have adopted the Savage Shippers Exception rule are contributory negligence jurisdictions, and that the rule doesn't work well in states where comparative negligence is the norm. I'm wondering if you have any thoughts on that, and how, if we were to agree that the shippers exception is something that should be adopted, how would that work in practice?
Okay. First of all, thank you for your question. I don't agree with that assessment from plaintiff's counsel. Last time I checked, only 4 states in the entire country are contributory fault jurisdictions anymore. So 46 of the 50 states are comparative fault states. And not every state has addressed whether to adopt Savage or not. Michigan is the 30th state to address it. And again, as you noted earlier, Justice Welch, the lower courts and the federal district courts applying Michigan law have applied Savage. Of those remaining 29 states, 28 have said Savage is consistent with our common law, with our contributory fault system. There's only one state that has rejected that approach. So I don't agree that Savage is a relic of contributory fault. I don't agree with that. It fits within comparative fault, as 28 of 29 states have found. So Savage was issued by the Fourth Circuit in 1953. It was based on a set of federal motor carrier regulations in existence at that time that were very similar to the ones we have now, but not identical. But on the duty to secure, it was awfully similar. So Savage is issued in 1953. 10 years later, Michigan adopts the Motor Carrier Safety Act and the federal motor carrier regulations, which were inspired by Savage. Regulations were rewritten after Savage based on the findings and the holdings of Savage. And Michigan chose to adopt those regulations. Now, that's 1963. Things have obviously changed since then. 1979, this court issued its decision in Placek and abolished contributory fault and adopt comparative fault. The legislature soon followed suit and adopted as a matter of statute. The Motor Carrier Safety Act has been amended repeatedly. I don't have the specific dates right in front of me, but after 1979, I believe the Motor Carrier Safety Act was amended in 1984, 1999, and 2005. 3 amendments after Placek, after contributory fault was abolished in Michigan, the Safety Act was amended. No changes. So I don't agree at all that it's a relic of contributory fault. It fits within comparative fault. And the regulations in Savage fit within comparative fault and fit within traditional tort principles in Michigan, primarily foreseeability. I've addressed control earlier, and then also reliance. Again, the Spence decision is essentially a reliance decision. The shipper loaded the cargo, secured the cargo, and told the guy, hey, it's fine, you don't need to do anything else. Again, reliance, control are traditional concepts under Michigan law, and so is foreseeability. That of all the duty questions, foreseeability might be the most important. And not only in this case does the unforeseeable nature of the injury implicate the common law, but I also believe that it implicates the regulations here. The testimony that really sticks out in my mind in this case, first of all, the testimony in this case was remarkably similar. The experience of truck drivers in Michigan is identical to those around the country. But the testimony that really sticks out in my mind was driver Anderson, who said, nobody knows what the load is going to do. That really sticks out in my mind. Nobody knows. DTE doesn't know, the driver doesn't know, the Ferris people don't know. Again, containers on the ground, it's loaded at a 45-degree angle back up onto the truck. The truck then goes on the highway. These are loose materials, it's a scrap metal. Nobody knows what the material is, how it's going to shift during that entire process. And because of that, the driver is entrusted with the duty to inspect and the duty to secure, not the shipper, because nobody knows what it's going to do, but who's in the best position, who's got control of the container and the contents, who's in the best position to implement safety measures. It's the driver. And again, the testimony was completely unanimous on this. Plaintiff was adamant about whether other people told him how to do his job or did he take direction from anybody else? And no, he was adamant. It's my discretion, my decision. I'm a driver. Again, not any, you can't be a 16-year-old kid with acne and show up and say, I want to haul this container of steel coils or scrap metal or what have you. Drivers are highly trained. They require licensure with a CDL license. The Federal Motor Carrier regulations impose continuing obligations to be educated about the regulations on employers, employees, drivers, shippers, carriers, everybody. And Mr. McMaster was trained on the job. His nephew was an experienced truck driver and told him how to do his job. Mr. McMaster was trained how to lift the container onto his truck. He was instructed on whether to apply securement devices. He was instructed, don't open the door and stand behind it. He was instructed on all of those things. These are highly skilled individuals, and it makes sense that they should be the ones ultimately responsible for securing, because again, they're the only ones with control over the container during the entire haul.
Thank you.
Justice Zahra?
No questions at this time. Thanks.
Mr. Diemer, you have a little bit over 3 minutes. If you want us to hear anything else, please proceed.
Let me take my notes.
No problem.
I believe I covered the material I was hoping to cover, and I really appreciate the questions. Happy to answer anything else before I sign off.
Thank you so much. Are there any additional questions for Mr. Diemer? Okay, Ms. Patel.
Thank you, Your Honor. A couple of points. First, Justice Welch, I just want to make clear, my argument wasn't that a majority of the jurisdictions have contributory fault, are contributory fault jurisdictions as opposed to comparative fault jurisdictions. My argument is that all of these cases, even though they've been adopted in those jurisdictions, have not addressed whether or not the Savage Doctrine is compatible with comparative fault. They never looked at that framework. They never addressed whether they just took the Savage Doctrine and incorporated it into that jurisdiction's law. So that was my argument with that. I just wanted to be clear on that. The second point with the Spence decision, I think I fundamentally disagree and read Spence differently than defense counsel. Spence did analyze and look at Savage, but it did not adopt Savage in the way that defense counsel is saying. Spence looked at Pennsylvania common law and looked at Pennsylvania common law to set forth what the duty of the shipper was in that case. To the extent that the court did look at Savage, one, it said that even under the Savage Doctrine, the shipper in that case had a duty to act because there was a question of fact as to whether the defect was latent. And second, I think that, and more importantly, they looked at it to say that the Federal Motor Carrier regulations at issue do not comprehensively ascribe the duties applicable only to the driver, that there is space when reading these regulations for the shipper to be held liable. And then the question becomes, if that law is not abrogated, if the common law is not abrogated, then what law fills the space? And the Spence court looked at Pennsylvania common law, and they also addressed Savage. And in my reading of the case, they adopted the Pennsylvania common law and then said that even under Spence, the defendant in that case owed a duty of care.
Ms. Patel, I'm wondering if you can answer. I appreciate your position that we should not adopt the Savage rule, but let's say we disagree with you on that, and we do believe that it's consistent with common law. I'm wondering if you can respond to Mr. Diemer's argument where he says there does not exist a genuine issue of material fact on the record about the latency issue. And what evidence would you point to on the record, or that's in the record, of why there's a question of fact as to latency that would require, a remand to the lower courts?
I think that the question, it goes to whether the issue was foreseeable. And although I think that the defect was latent, because although the defect, you could see the defect, you couldn't necessarily know that that defect was going to cause what happened, which is the load to come down and hit Mr. McMaster. I think that there's a lot of case law that says that weighing whether a defect is latent or not is an issue of fact, that even when the defect itself is, they can see that the pipe was placed the way that it was piped. I think he testified to that. That's in the record. Whether that defect was latent or not is still going to be a question of fact that should be sent to the jury as opposed to decided as a matter of law.
But are there particular facts about this load or the nature of the placement or what have you? I understand that in many cases where there are disputed questions factually about, placement and material and the effect of how it's placed and maybe metal on metal or shifting or whatever that may be. There obviously can also be a record that even taking all the facts in the light most favorable to the plaintiff, there's no question that the defect wasn't latent. So what particular facts, I guess, about this, about the nature of this load or any of the conduct that is relevant to it, creates the question of fact that precludes summary disposition?
Well, I think that the fact that the load wasn't moving at the time that he inspected it. When he did inspect it, he thought that the load was stable in that moment. And then second, when he opened the door and checked to see whether the load was moving or not, the load was still stable at that time. So I think when you look at a definition of what latency means, the load was stable at one point in time, but then shifted and then became unstable. I think that creates a question of fact as to whether whether the defect was latent or not, because it couldn't readily be seen and didn't readily show itself in that moment to be moving and to be a threat, an immediate threat.
Okay, thank you.
You have a bit of time. Are there any additional questions for Ms. Patel? Anything else you would want to make sure we hear?
Yeah, one thing that I think I do want to address is that defense counsel brings in a lot of policy arguments and factual arguments to define the contours of the duty at issue, going into whether or not it was foreseeable, whether or not there was reliance, who had control. All of these issues feed into the question of whether or not there was a common law duty. So I think that in the first instance, the court should not be deciding that there is no common law duty at all. And then as to the particulars about what defines the common law duty and the foreseeability and the control and the reliance, those are questions of fact that need to be sussed out, and that especially when there's a differing factual record as there is here. Like, we argue that it was foreseeable that the way that DTE loaded the scrap container would create a latent defect, that they had, because they undertook to load the container themselves, that they had a common law duty to load it in a reasonable manner. Now, what is or isn't reasonable under these circumstances will turn on a factual question and will have to be developed further. But DTE that's not what DTE is asking this court to hold. DTE is asking this court to hold that as a matter of law, under these circumstances, it did not have a duty of care to act at all, that these regulations have abrogated Michigan common law and that there is no duty of care to act. And I think that's a very dangerous road to take Michigan law down, because now we are then weighing the different roles of the parties and weighing who has a greater duty or lesser duty to act under any given circumstances. And that's not what the parameters or the role of deciding a duty of care in the first place. It is for a trier of fact to apportion out the fault and apportion out who has how much fault in any given circumstances. Duty in the first instance is about whether you have a duty of care in the first instance. I say that earlier. Whether you have a duty to act in the first place. So I don't think that Michigan law should be taken to say that in these circumstances that you have no duty of care to act at all. In terms of the Savage doctrine, I know that I've gone over this quite a bit, and I don't think that doctrine has a place under our comparative fault statute, because the concepts that case brings up, of the last clear chance doctrine, weighing the relative duties of the parties, the primary versus secondary duty. All of these concepts are based on contributory negligence principles. And that Michigan has walked away from that doctrine. So if we're going to accept that under the federal motor carrier regulations that have been adopted, that there is space for both the shipper and the carrier to be liable in any given circumstance, then what defines the shipper's duty under that parameter should be defined by Michigan law, which is Michigan common law. And unless the court has any other questions.
Let me see. Are any additional questions for Ms. Patel? Thank you both. The case will be submitted.